Hello and welcome to the Blackstone Solicitors channel. Today, we're exploring a topic that can have a big impact on homeowners, developers, and businesses alike: the Rights to Light Act. If you've ever wondered whether a new building can block sunlight to your property, or whether you can claim compensation for lost light, this video will explain the essentials and why understanding your rights matters. Imagine this. You've lived in your property for years, enjoying bright sunlit rooms. Then one day, a neighbor begins construction on a new extension or building. Over the weeks and months, you notice that your windows are receiving less sunlight. The room feels darker, the garden looks gloomier, and you start to worry, do I have any legal protection? This is where the Rights to Light Act comes into play. The law recognizes that access to natural light is an important part of enjoying your property. If windows have received natural light uninterrupted for a certain period, the property owner may have a legal right to continue receiving that light, and any obstruction could be challenged. The legal foundation for rights to light comes from the Prescription Act 1832. Essentially, if a window has received natural light for 20 years or more without interruption, the property owner can claim a legal right to that light. This right is enforceable against any new development that would significantly reduce the amount of light entering the property. But how do we determine whether the light is significantly reduced? Surveyors and courts often use the Waldron method to measure light levels and assess whether the reduction materially affects the room's enjoyment. It's not about absolute darkness, it's about whether the remaining light is sufficient for normal use. It's important to note that planning permission does not override rights to light. Even if a neighbor has received planning approval for a development, it may still be unlawful if it infringes an established right to light. This often surprises property owners and developers alike, highlighting the importance of seeking legal advice before construction begins. This is where specialist solicitors, like us at Blackstone, make a real difference. We advise homeowners, landlords, and developers on their legal rights and obligations, help assess potential claims, and negotiate practical solutions. Acting early can prevent disputes from escalating into costly litigation, protect property values, and save time and stress. In summary, the Rights to Light Act protects property owners who have enjoyed natural light through their windows for a long period, typically 20 years or more. Any new development that significantly reduces that light could give rise to legal claims for compensation or injunctions. Understanding these rights early is crucial, whether you're buying, selling, or planning construction. At Blackstone Solicitors, we specialize in property and construction law, helping clients protect their rights, resolve disputes efficiently, and navigate complex legal frameworks. If you're concerned about a new development affecting your property's light, get in touch with our team. We'll help you understand your options and take action to safeguard your home or investment. Thank you for watching. For more insights on property law, neighbor disputes, and construction law, don't forget to subscribe to our channel and stay informed about your legal protections.